Good afternoon. We are delighted to welcome you to the first of our two-part webinar series, which provides an overview of key construction and adjudication cases of 2016. This first webinar will focus on the top 5 construction cases. In today's webinar, we will be highlighting the key fact and legal points of each case, identifying specific lessons to be aware of for construction contracts and claims. The second webinar on Tuesday 28 February will focus on the top 5 adjudication cases of 2016. All of the webinars from our series have been recorded and are available on our Vimeo site, so if you couldn't join us live or would like to listen again or share with colleagues, please make sure to visit that. I am Lee Herd, a solicitor in the Construction and Special Projects team, specialising in construction and engineering dispute resolution based in Edinburgh. I am joined today by Lindsay McCormick, a trainee solicitor in the team. The team regularly advise on construction contract issues and disputes across a range of projects and clients. We therefore have a great deal of experience working in court, where our arguments have to fall in line with ever-evolving judicial approaches to contracts. This experience helps us to form the basis of our strategic advice and what we're going to share with you today. I am now going to hand you over to Lindsay, who will discuss this webinar's agenda.
Thanks, Lee. We will look today at the top 5 construction cases of the last year, and for each we will provide a summary for the factual background, along with an analysis of the key facts and legal points, whilst drawing out some lessons that can be learned and which we hope can be considered and applied in your future contracts and claims. I will quickly run through the cases we are going to look at today. Firstly, Grove Development Limited v Balfour Beatty Regional Construction Limited, where commercial common sense did not allow Balfour an extra payment cycle. Boyds v Freybury Structures Limited, where there was a dispute concerning the validity of a payment notice, providing an important reminder of the high bar the courts have when it comes to determining the validity of payment notices. Jobby Property Investment Limited, the Interiors Group Limited, which is a classic example of the smash and grab trend from this year, where contractors relied on technical errors made by the other party to claim full payment of notified sums. Surrey and Sussex Healthcare v Logan Construction, the most recent case we will discuss today, which provides additional guidance as to the validity requirements for payment applications, payment notices and pay less notices under construction contracts. And lastly, Graham Leslie v Farrer Construction Limited, a case which demonstrates that employers' overpayments to contractors are not always recoverable, even where the contractor has made a large profit from that overpayment.
Whilst you'll have noticed that these cases are all English cases, most of the law in this area is common across the border, and the English courts naturally have a larger number of disputes and appeals than we have here in Scotland. So key lessons and the likely future approach that Scottish courts or adjudicators may take can still be learned from all of these cases, and that is why it's important that we look at these today. You will also notice as we go through today's webinar, there is a trend in the content of these cases, as many of them relate to payment. However, this does reflect the trend in the type of disputes referred to the courts in 2016, and therefore we felt it was important that we look at each of these decisions and take away from them what we can to avoid similar issues in future.
We begin with Grove Development Limited v Balfour Beatty Regional Construction Limited. The factual background of the case is that Grove appointed Balfour Beatty to design and build a hotel and serviced apartments adjoining the O2 Arena for a contract sum of just over £120 million. The contract completion date was the 22nd of July 2015, and the parties had agreed that there would be staged interim payments throughout the intended construction period. The contract incorporated a schedule setting out 23 dates on which valuations and interim payments would be made, the latest of which was July 2015. But the works were not completed by July 2015. The parties entered into negotiations about extending the payment schedule beyond the contractual completion date. However, an agreement was never reached. Balfour Beatty then issued a further interim payment application for over £23 million in August 2015. The question for the court was, did Balfour have the contractual right to make this interim payment application? Balfour had already taken the dispute to adjudication in a so-called smash and grab adjudication, a trend we will discuss shortly. They succeeded and were granted payment of the full £23 million sum applied for on the basis that no valid pay less notice was served on time in response by Grove Developments. The court held that the fixed schedule for interim payments up to July 2015 only was compliant with the Construction Act, and as there was no agreement to extend the payment schedule, Balfour Beatty had no contractual right to further interim payments. The next valuation and payment was not therefore due until practical completion was achieved. The court noted that parties could have anticipated an overrun and provided a mechanism to deal with this in the contract. In the absence of any such mechanism, implying a term that further interim payments should be made would be contrary to the express terms of the contract. It is not uncommon for parties to agree payment schedules that don't address what will happen if the works are extended beyond the expected completion date. Although this doesn't fall short of being an adequate mechanism for payment as required by the Construction Act, the Grove decision illustrates the dangers of this from a contractor's perspective, with potentially significant cash flow issues between the date for the last interim payment and the final accounts. To avoid this, contractors should seek to include a mechanism in any payment schedule, for example, that in the event of a delay beyond the expected completion date, further interim payments will be permitted, say, on the last working day of each month.
Thank you, Lindsay. Moving on now to look at our second case of today, which is the case of two French parties of Bouy versus Fabry Structures, in which there was a dispute concerning the validity of a payment notice served pursuant to the payment schedule in a subcontract. The facts of the case are as follows. The subcontract provided for the subcontractor, Fabry, to apply to the contractor for interim payments in accordance with an agreed payment schedule. The payment process was set out in detail within the schedule, which was then an appendix to the contract, and included the relevant dates for each step of the process. From March 2015 to September 2015, the dates in the payment schedule in the appendix followed a consistent pattern whereby the payment notice and pay less notice were to be served on the same day on or around the 20th of the month, and in any event within 5 days of the due date. However, the dates differed for the process of the month of October. For October, the appendix stated that instead of the sums being due on the same day as the pay less notice, both being within 5 days after the due date and 2 to 3 days before the final date for payment, as it had been for every previous payment cycle, the contractor's payment notice was due to be given on the 23rd of November. The 23rd of November was also the final date for payment. It was 7 days after the due date and later than the pay less notice dates. These are all issues in relation to the Construction Act. So what happened? The subcontractor duly submitted its application for the October payment, and the contractor issued its payment notice as per the schedule on the 23rd of November. The subcontractor argued later that the notice was invalid on the grounds that it was late in terms of section 110A of the Construction Act, which states that the date for a payment notice must not be more than 5 days after the due date. The contractor, in response, argued that its notice was valid as it complied with the contract and was served in time in accordance with the payment schedule. The court held that the agreed payment process and timing in this case were clear from the dates for the first application for interim payment and the consistent pattern that flowed thereafter. The dates showed that the payment notice and pay less notice had the same deadline in each month and fell within 5 days of the due date. The court said that they could not see any reason why the parties would intend for that consistent format to be varied for October. There was therefore, the court held, an obvious error in the payment schedule for October, and the contractor's payment notice had therefore been served out of time and was invalid. This decision was arrived at based on a very specific set of facts and has not been especially welcomed due to the uncertainty it raises in circumstances where the contractor complies with the letter of the contract as agreed. However, it is an important reminder to carefully check your dates when issuing notices, and if there is any doubt between the contract and the Construction Act or scheme, then take a cautious approach and issue the notice on the earliest date that it could be due.
Thanks, Lee. Now we look at Jobby v. the Interiors Group, a classic example of a smash and grab case. There has been a recent trend in the construction industry to take advantage of the 2011 amendments to the Housing Grants, Construction and Regeneration Act 1996. Colloquially known as smash and grab cases, contractors have been relying on technical errors made by the other party, typically a failure in the form or timing of payment notices, to claim full payment of notified sums where the employer has failed to comply with the payment notice provisions. The contract in this case was an amended JCT 2011 Design and Build, which required the contractors to submit an interim application for payment, giving their valuation on the 8th day of every month. This would then be followed by a certificate from the employer detailing the sum to be paid. On the 7th of January 2016, in response to a request by the employer, the contractor sent an email attaching a breakdown described as an initial assessment for valuation. This was at odds with the way that previous interim applications had been dealt with, both in the way it was described and also because it was not brought up to the due date, which would have been the 8th of January. The contractor argued this was nevertheless a valid interim application for payment. The employer, who had not issued a pay less notice in response, disputed this for several reasons. It said that the email transmission did not comply with the requirements for service under the contract. The email was not labelled as an interim application. It did not state a sum considered to be due, and it was not accompanied by supporting documentation as required by the contract. The judge held that the employer's first argument rejecting the electronic transmission of the application was unfounded. This is because electronic service was not expressly or impliedly excluded by the relevant notice clause, and in any event, the employer had accepted 6 prior interim applications by email, so could not now argue that email service meant an application was invalid. Ultimately, however, the judge considered that the contractor's email on the 7th of January 2016 was not a valid interim application. The reasoning was that this type of initial valuation had never been dealt with as a valid interim application by the employer before, and it was not sufficiently clear that it was intended to be an interim application because it was not sufficiently unambiguous. Although you can see why the contractor tried to argue this was an interim application, the judge's decision is consistent with the court's reluctance to give effect to ambiguous payment applications that do not strictly comply with the requirements agreed to in the contract. Clarity is therefore critical. If a notice is supposed to be an interim application, then it should say so. The decision in this case is a clear indication of the court's reluctance to give effect to alleged interim applications for payment containing any ambiguity. Clarity is critical. Although Job A relates to contractors' applications, the requirement for clarity applies equally to payment notices and pay less notices on behalf of the employer. Care should therefore be taken to ensure that all contractual notices comply with contract requirements and are clear, unambiguous, and served timeously.
Thank you, Lindsay. We now move on to the fourth case of the webinar, which is a very recent case, that of Surrey and Sussex Healthcare against Logan Construction, which was heard in 2016, but the decision was only issued in January. So the facts. Logan was employed by the Trust through a JCT intermediate building contract with Contractors Design, the 2011 edition. The contract was to refurbish various parts of East Surrey Hospital. The dispute arose on the validity of the content of an interim payment notice and a pay less notice. Logan made no applications for interim payment following practical completion of the works. However, the Trust issued interim certificates as required by them under the contract. Subsequent to the Making Good Defect certificate being issued on 24th August 2016, both parties entered into discussions about the final accounts. However, despite this triggering another interim payment cycle, neither an interim payment application nor a certificate for interim payment were issued. According to the contract, due to the absence of an interim certificate from the Trust, Logan was then entitled to submit its own default payment notice. This also triggered a 28-day period for the issue of the final certificate, falling due on the 21st of September 2016. The parties' QSs agreed to meet on the 21st of September 2016 to discuss the final accounts. Just before midnight on the 20th of September 2016, Logan emailed a spreadsheet to the Trust entitled Interim Payment Notice, bracket, Clause 4.10, close bracket, with a balance of over £1 million. Given that the covering email had been sent late at night and that there was no reference to the interim payment notice within the covering email itself, the Trust was under the impression that the document's purpose was to convey Logan's views on the final account ahead of the meeting the following day. Further, at the meeting itself, there was no reference to Logan's documents. As a result of the parties being unable to reach agreement on the final account, the Trust then issued the final certificate for a substantially smaller amount of just over £14,000. In their covering email with the final certificate, the Trust addressed Logan's interim payment notice document as being out of date and void, and therefore all that was due to be paid was a smaller sum in their certificate. This issue, unsurprisingly, went to adjudication, where Logan argued that the Trust's final certificate and covering email did not constitute a valid pay less notice, and that according to the contract, in the absence of a pay less notice, they were due the full sum as set out in their interim payment notice. The adjudicator found in Logan's favour and awarded them the sum of over £1 million. So, the dispute was then referred to court. In the court's decision, the first question that the judge, Alexander Nissen QC, had to answer was whether Logan's interim payment application was valid. He noted there was a high threshold to be met by any contractor when seeking to enforce an interim payment application where a timely employer's notice has not been served. With that said, Nissen went on to find that Logan had met this high threshold. The court's reasoning for this was as follows. Firstly, the relevant background of the case must be considered, including the fact that the dispute would never have arisen had the contract administrator issued an interim certificate and complied with its own contractual obligations. Secondly, the notice itself was not ambiguous and was in all of substance, form and intent an interim payment notice. Whilst the covering email had not made express mention of the interim payment application, the court decided that sufficiently indicated that Logan's intention was to issue an interim payment notice. The second question the court then had to answer was whether the pay less notice then issued by the trust was valid. The court did find that the pay less notice was valid and commented as follows. Firstly, the notice had complied with the contractual requirements as it stated the sum that was due and the basis upon which the sum had been calculated. This is the wording from the Construction Act. The adjudicator had focused too closely on the specific detail of the language and had not looked at what the overall message would have conveyed to the reasonable recipients. It was held that the reasonable recipient would have understood that the trust had made an error and that the final certificate would have been intended to reply to Logan's interim payment notice. Interestingly, the notice does not have to state that it is a notice. Nisson stated specifically, it is not necessary for a pay less notice to have that title or to make specific reference to the contractual clause in order to be valid. The question is whether, viewed objectively, it had the requisite intention to fulfil that function. The pay less notice could be served contingently. Therefore, the contract administrator can effectively say that if he was wrong about the invalidity of the interim payment notice, the final certificate would say everything required for it to act as a valid pay less notice. This case therefore highlights the need for both parties to a construction contract to be cautious when it comes to payment notices. The content, the form and importantly the context of the notice will all be carefully examined by the court when determining the validity of a notice. There appears to be no need for a notice to explicitly say what it is or for the notice to be referred to directly in correspondence such as covering emails in order for it to be valid, although we recommend that doing so would be better practice. Therefore, it is important for parties to take great care when entering into any discussions regarding payments. Employers must be alive to the fact that payment applications and payment notices may be valid even when served in unconventional circumstances. And contractors must also be aware that even where the employer contends a notice is invalid, they can still serve a pay less notice contingently as they still have the requisite intention to respond to that notice.
Thanks, Lee. Our last case we will look at today is Graham Leslie v. Farrer Construction. Mr. Leslie and Farrer Construction entered into an oral framework agreement which provided that land would be identified for Mr. Leslie to acquire, Farrer Construction would be instructed to design and construct housing on that land to an agreed budget, Farrer Construction would be paid its build costs, which were not defined, and the parties would split the profit made on the site when sold on the open market. 5 sites were developed in accordance with the framework agreement. During the course of the 5 developments, Farrer Construction submitted applications to Mr. Leslie for round sums without any supporting evidence. Mr. Leslie accepted the sums on the basis that they were in accordance with the agreed budget. On the completion of each site, the build cost and profit share were agreed and without any further information being provided. Mr. Leslie accepted that the build costs were within the agreed budget and made significant profits on each site sale. However, the relationship between the parties subsequently broke down, and Mr. Leslie sought to reclaim the sums which he had allegedly overpaid. The Court of First Instance held that an employer could not recover overpayments which it made at the contractor's request without further investigation. Mr. Leslie then appealed this decision. However, the Court of Appeal upheld the Court of First Instance's decision. The Court found that Mr. Leslie's key concern was to ensure that build costs stayed within the budget in order to protect the large profit anticipated and that was achieved on each site. Mr. Leslie did not audit the build cost claimed, and they fell in line with the projected budget costs, and it was more time and cost effective to accept the sums claimed for without any further analysis. Therefore, as there was no allegation of fraud or misrepresentation, the court found that Mr. Leslie made the final payment as a conscious commercial decision to close off each site and allow him to realise each profit. As such, he was not entitled to claim for any overpayment. This case serves as a warning to employers looking to deal with final accounts quickly. Where a commercial decision is made to accept a sum applied for without any further line of inquiry, the employer will likely lose its right to challenge that sum at a later date. It is worth taking the time to consider sums applied for in order to protect against any unrecoverable overpayment.
So, what can we take away from today? This webinar has highlighted that it is very important to keep up to date with recent case law. The law in this area is constantly changing, and it's especially important in the construction industry to stay alive to these changes. Payment notices and pay less notices have been a consistent theme in case law disputes in the UK over the last 3 or 4 years, and the sheer volume of these disputes indicates that the payment covered by the Construction Act is an issue that requires extra care by all parties and representatives. The cases regarding payment notices in 2016 have significantly developed the position on this topic, and we anticipate this is likely to develop further as this year goes on. We'll now move on to questions, and we seem to have quite a few on the payment application and payment notices in relation to the Jobby case and the Surrey case. I would start by saying that the Surrey case is more recent and so has kind of moved the law along a little bit since the Jobby case. And the question I've been asked is, when discussing the Jobby case, is it commonplace, when you say applications should state clearly that they're interim applications, would this stop applications basically being valid if they didn't explicitly state that they're interim applications? I think from the Surrey case it's clear that that's not the case, and the court was clear that they weren't making a different rule for interim applications, payment notices and pay less notices. What they said was essentially earlier cases such as Jobby had said that if a notice wasn't properly entitled as something else, then it would suggest that the payment notice or pay less notice or payment application was not actually that, as the parties would have entitled the document that had they intended for it to be a payment notice, for example. However, the Surrey case then says you have to look beyond that, and the test is not just what the sender has entitled the document, but what the reasonable recipient would think when receiving that document. So I think where we are with it is that the intention of parties is always can be now looked at when deciding whether or not notices are valid and what they intended to be. But as a matter of good practice, we would recommend when submitting payment applications that they are labelled clearly as such in order to avoid any sort of dispute as to what the underlying intention actually was. And if you receive any document which, as employer, you think there's a risk that it could either be a payment application or that could be a default payment notice, that you do make sure you serve a notice, if even just only on a contingent basis. And I think that brings us to the end of our webinar even. We have a few more questions, but we'll maybe pick up with those people directly. And if you've got any other questions following on from the webinar, do feel free to contact us. We do hope that you've enjoyed this webinar and found it both informative and useful. And we look forward to welcoming you to future webinars in the future. Thank you.